Okay. We have also Professor Magdalena Sitek here, yeah? No? Or maybe she will join also. I can see now her. Okay. And last but not least, Dorottya Biczi from Hungary, from István Széchenyi István University. I'm sorry, Dorottya, for my pronunciation.
Yes, thank you. And
welcome
excuse
you.
me.
Yeah. Could you tell us your name of your university in your original your mother tongue?
Széchenyi István University.
Beautiful. Okay.
And my presentation title is wrong in the program. So it's
Okay.
a little bit different in my presentation.
Okay.
But I think it's not a problem.
Yeah. So we will start from our keynote speaker. Francesco Bariffi is from University Carlos III of Madrid. Our faculty, our university has very good, we have very good cooperation with Professor Oscar Pérez de la Fuente from University Carlos III of Madrid. And I hope that he will also join in our session a little bit later. But first of all, Professor Francisco Bariffi, Artificial Intelligence and Human Rights in Global Governance, Safeguarding Vulnerable Groups in the Age of Emerging Technologies. Francesco, the floor is yours.
Okay. Should I sit here so that the rest can?
Yeah.
Okay. Okay, so it's 15 minutes?
15 minutes, okay.
I'll try to. Hello, everyone. Hello, everyone in the room, and hello, everyone there in the digital world. Well, it is a pleasure. I thank very much the university for this kind invitation. It's a pleasure to be part of this network. And I would like to come here and share with you very briefly. I'm aware our time is very limited. So I will skip some of the details and go into the main ideas. I prepared this presentation based on three parts that I have been working on. A first one, which is the UN approach towards AI. What is the framework for addressing AI within the UN system, and how this is proposing a new paradigm shift on international relations. How this technology is also in some way proposing a new era for international relations, mostly based on the emergence of private actors as the main actors of this new world. Then I will briefly address to the impact of AI on human rights, where I will focus on four specific dimensions. And lastly, I will try to outline or emphasize on how this impact affects particularly four specific human groups, which are considered in a situation of vulnerability. That is to say, persons with disability, children, women, and elderly. So very briefly, just not to spend much time in this first approach, just to note that the UN has started to deal formally with AI just quite recently in 2017. And it was maybe in the last 2 years where we have seen a real takeoff of the UN in addressing AI as a global and mainstream issue. Perhaps this is enshrined in the adoption of the General Secretary new agenda for peace, as you know, part of our common agenda. And basically the Secretary General outlines the artificial intelligence as a transformative technology, which has both opportunities and threats, as we have seen in the morning. So the UN poses this technology is a dual use nature, which allows to revolutionize humanitarian responses, healthcare, and conflict preventions, while also enabling harmful outcomes. The main concerns outlined by the UN in relation to AI are lethal weapons systems, as we saw here in the morning. Also, another of the main concerns is deals with misinformation and how this information may impact international relations and international order. And lastly, also the Secretary General emphasizes on cybersecurity and how this may affect the new order. Under this framework, the UN Secretary General proposes a new governance within the UN system, considering that the UN is perhaps the main actor in the global era and that this technology has to be addressed collectively. So basically, the UN advocates on a multi-stakeholders, rights-based governance to model and harmonize AI standards and guidelines. Switching into the impact of AI in human rights. Well, of course, the impact of this technology is a mainstream impact, which affects almost all the different dimensions of human rights, but I will focus on 4 core aspects of human rights, which, by the way, they belong to what we could call the very nature of human rights, of natural rights. They come even from the Enlightenment era. These are the foundationals of our human rights discourse, and these areas are human dignity, equality, privacy, and liberty of opinion. As regards dignity, this technology poses a significant threat to the notion of human dignity. I cannot stand into this, just to note that when this technology is associated, for instance, with neuroscience, we get neurotechnology, and this technology, when it's associated with genetics, we get genomics and genetic engineering. And these 2 technologies, neurotechnology and genetic engineering, they themselves can be so transformative of our human nature that it will mean a significant impact on our common notions of human dignity. Another aspect, another important impact of this technology is on the area of equality. Equality where we can divide or distinguish like 3 levels of affection on the rights of equality. Perhaps the primary one is what we call access to the technology, or what is more commonly known as the divide. The divide or the inequality or the circumstances, personal, intellectual, geographic, economic, which hamper individuals from accessing this technology, which is a real threat to equality. The second one would be what we can call accessibility, namely this technology has to be accessible for all groups, and this has a tremendous impact on disability rights and the rights of elderly. And lastly, also related with equality is the notion of bias, which bias is like an emerging scenario, which poses the digital dimension and this new technology, where we where we face a new form of discrimination. A new form of discrimination. In third instance, this technology poses a significant risk to privacy. Privacy has been traditionally a very important human right, but it was related most to correspondence and the protection of home. But this new technology has made our privacy to escalate to another level. and everything we do online is registered. It generates some sort of a digital print, which in terms may affect our privacy. And also this possibility to affect privacy also creates a new scenario of the possibility of massive surveillance, as we have seen this morning with the notion of AI totalitarianism. And lastly, of course, the impact of this technology on the right to opinion and access to information. We have seen how this technology, especially the recent breakthroughs, which allows the creation of materials which resemble reality, where we cannot tell what is true or what is false, and the power of manipulation of this technology. This is affecting significantly both the right of opinion and the right to access information, which are intertwined. They are both sort of the two sides of the same coin. If I don't get reliable information, I cannot really exercise my right of opinion, and so forth. So having said this, and I will just try to wrap up this presentation, I have outlined very briefly the approach of AI from the UN system. Then what are the main impacts of AI in human rights in these four core areas? And let me now switch into these four groups, selected groups on situation of vulnerability. I acknowledge that I have selected four groups, and there are several other groups like LGBTQ community, like indigenous communities, like migrants, like racial discrimination, which are also affected by this technology. But I will focus on these four very briefly. And I will just outline what are the two main concerns in relation to each group in 2 minutes, so I can wrap up in time this presentation. So in relation to persons with disabilities, what are the main concerns of AI in relation to persons with disability? Well, I would pose firstly the affection on dignity, considering that this new technology, especially genetic engineering and neurotechnology, is offering a new scenario of fixing impairments and fixing disabilities. So this is quite transformative for the very notion of the social model of disability and the identity of persons with disability. If you have a technology which basically is telling, I can heal you, I can correct you, I can make you normal. And also the impact on equality. Persons with disability face the whole three problems related with equality: access, accessibility, and biases. On second turn, I will switch to women. Women are, of course, a group which is specifically affected by this technology in their human rights. I will select two approaches, two main concerns in relation to women. On the one hand, bias, again. Algorithms have shown that women are among the groups which are usually biases on, but also in relation to what we could call digital violence. This technology is creating a new form of violence, of digital violence, but is specifically directed to women. Think about deepfakes, for instance, in which, when you look at the impact, it is significantly affected women in a particular way. And third time, and I will finish in 1 minute, I promise, I selected the group formed by children. And we all know how this technology is affecting our kids and the young ones. The violation of their rights are multiple, but I will focus on two, perhaps the most concerning. One is on how this technology is affecting on the development of their personality. We see how this technology is really rewiring the brains of our young people, creating a significant impact on their mental health, on their possibility of attention and reasoning. So it's really concerning how this technology is affecting the personality development of our children. And also the second aspect of concern that I would like to align in relation to children is, again, digital violence. As I mentioned before, there is a specific violence which is directed for women, and there is also a specific form of violence which is directed to children and affect their significantly. Unfortunately, I cannot go deeper. We can in the Q&A if you wish, but let me now search to the last one in order to wrap up my presentation. The last group that I have considered of special concern is the one composed by the elderly. And these groups, the main two concerns for these groups are as follows. First, the problem with the digital divide. The persons, elderly persons, are significantly affected with the digital divide, with their problems to understand this technology. They belong to another era of the analogy era, and for them it's very hard to understand and to access to this technology. But the other aspect which is concern of the elderly is that this technology is undermining more and more their human interaction. We trend to use technology to care for the elderly. We try to design robotics and assistive technologies in the home for the elderly. We force the elderly to use the banks online and to use the internet. And the truth is that this collective is claiming more and more for human interaction, not digital interaction. So this is certainly a big concern. To wrap up, basically, there was a very brief approach into the impact of this technology on human rights in general, emphasizing how these technology impact, especially these four groups in situation of vulnerability. Thank you.
Thank you very much, Francisco. Thank you very much, Francisco, for your interesting presentation. So we have also, I'm very glad because we have my colleague from Pakistan, Furkan Ahmed, who will be discussing during this session. But question is, so discussion will be on the end of session or after each presentation? What do you think? Maybe
I guess at the end of the session, yeah.
Yeah, because yeah, we will know how long we have time for discussion. But thank you very much, Francisco, and welcome also Oscar Perez de la Fuente from Madrid University. Thank you very much for joining this session. And now let's jump to Italy, because there is Francesco Cirillo from University of Tuscia, Viterbo. Yeah, I'm sorry for pronunciation.
Perfect pronunciation.
And a little bit different view on the artificial intelligence. Your presentation is titled "Artificial Intelligence and Cognitive Manipulation: Are European Legislators Chasing Shadows?" Yeah. Okay, Francesco, the floor, digital and analog floor, is yours. Okay, so 15 minutes, it will be great.
Thank you, Professor, for giving me the floor, and thank you for this wonderful opportunity. Well, the European Union presents itself as a global leader in regulating artificial intelligence, embodying the so-called Brussels effect. With the AI Act, the EU promises to safeguard fundamental rights, mitigate risks, and ensure somehow transparency. But can we truly say this regulation is proportionate, balanced, and consistent with the EU own principles? So today I aim to offer a critical reflection, maybe a too much critical point of view on this regulation, hoping that forums like this can also host dissenting voices, not against the Union itself, but against certain policies that, while widely implemented, may not be universally defensible. So we'll explore how the AI Act lacks clarity in defining cognitive manipulation, betrays the risk-based approach it claims to follow, and maybe violates some fundamental principle, like the principle of proportionality. In essence, it seems Europe has embarked on a hunt for shadows, chasing ghosts, chasing shadows, while hindering innovation more than protecting rights. My critique will remain apodictic for now, with a promise to elaborate further in a detailed paper. And however, my starting point is a factual premise. I cannot measure risks of dystopian scenarios, but I'm certain of a much greater and immediate threat, a reality, not a risk, that European Union might fall behind in the global race for innovation. First argument, cognitive manipulation is an ambiguous concept. One of the cornerstones of this regulation is the prevention of cognitive manipulation, but let us pause for a moment. What is cognitive manipulation really? The term appears to assume that the existence of human choices entirely free from external influences. Yet this idea is fundamentally unrealistic. Every decision we make is shaped by cultural, social, biological, or psychological factors. Advertising, education, social norms, politics, all these influence our choices. And digital platforms employ techniques like personalization or behavioral marketing, which are legitimate activities for now. Where does acceptable influence and manipulation begin? The AI Act does not clarify this distinction. Vague definitions of cognitive manipulations risks turning it into a kind of a justification for over-regulating neutral or even possibly beneficial technologies. This is not a constructive critique simply because the theoretical core itself is ambiguous. We cannot simultaneously affirm the existence of free will while claiming it is threatened by external factors, thus adopting both, a deterministic view of cognitive activity and at the same time, a libertarian view of cognitive activity. This is a philosophical problem. Second argument, the precautionary approach. The European Union claims that the AI Act adopted a risk-based approach. In practice, however, the approach is anything but calibrated to risk. It's precautionary. A true risk-based approach evaluates the specific context in which a technology is used and the tangible risks it poses. Instead, the AI Act preemptively classifies certain technologies as dangerous without considering their actual use, but the future use, the future possible use or use cases. For example, the outright ban on social scoring overlooks scenarios where this technology could be applied positively in controlled environments. The precautionary approach has two primary consequences. It stifles innovation. Startups and small business which cannot afford high compliance costs are more penalized, and it disadvantages Europe in the global race. While the EU fixates on restrictive rules, competitors like United States or China move forward with more flexible legal frameworks. Rather than stimulating technological progress, Europe appears to be paralyzing itself, chasing shadow. This is the argument. A framework that lists prohibited systems, high-risk categories, and systematic risk based on a top-down political decision is not risk-based. It is precaution, masquerading as regulation. Well, here we reach the crux of my critique, which is not directed at the Union itself, but a political orientation that I believe betrays some founding principles of European Union, and specifically the principle of proportionality. The AI Act may be fails to respect the principle of proportionality, a cornerstone of European law. The principle of proportionality requires that every legislative measures be legitimate in its purpose, such as, supported by a clear legal basis, suitable to achieve the stated objectives, necessary, meaning it's not excessive relative to the intended outcome, and balanced, well balanced, striking an equilibrium between competing interests such as innovation and rights protection. And my argument is that AI Act falls short on these fronts. There is an unclear legal basis. It's not evident which legal foundation allows the Union to regulate all AI as a single identity, which is not a single product. Treaties do not authorize such extensive control. AI is not a single product or a service. It is a suite of technologies impacting multiple sectors. A single EU regulation cannot reasonably extend into every domain of life in which we find AI. The Union legislates to remove barriers in a single market, not to raise barriers across all sectors. Dubious suitability. The goal of preventing cognitive manipulation is ambiguous, making it difficult to assess whether the measures are effective. How do we measure whether a technology has or has not protected cognitive activity? What degree of mental freedom should remain immune to manipulation or influence? Maybe there is also a lack of necessity, if not an absence of necessity. Blanket bans, such as the prohibition of social scoring, could be not strictly necessary. Less invasive solutions, such as transparency or accountability measures, could achieve the same objectives, or could be. Well, and then imbalanced regulation. The emphasis on protecting rights come at the expense of innovation, as a matter of fact, for now. This imbalance risks harming Europe's entire technological ecosystem with the GDPR, Digital Markets Act, Digital Service Act, and so on. In summary, we have a lot of rules and we don't have any or very few technologies at the moment in Europe. The EU Act, for these reasons, appears to be a disproportionate regulation, driven more by fear of a risk than by a rational and balanced evaluation. Conclusion, with a final doubt, here is the picture that emerges: an ambiguous concept of cognitive manipulation, a precautionary approach that stifles innovation, and a regulation that could violate or weaken the principle of proportionality, undermining the legitimacy of the intervention. But there is an even deeper question to consider. Does the European Union truly have the tools to ensure that its laws, regulation, or whatever, adhere to the principle it proclaims? Or we are witnessing a system that, in chasing shadows, risks losing coherence and credibility? The EU aspires to lead in safeguarding rights, but it cannot overlook the need for its initiatives to be grounded in law, in the rule of law, and in the principle of legality. Legislative measures must be based on a clear legal framework derived from treaty competences and impose rules that are not overly invasive, scientifically grounded, and free from arbitrary or indecipherable barriers. This is not just a question of artificial intelligence, it is a question of the future of European regulation itself. Sorry for the too much critical point of view. Thank you.
Francesco, thank you very much for your point of view on regulation in EU. I hope that it will be good base to discussion at the end of the session, because we have also other attempts to AI, for example, in China, yeah? Which is better, for example. But this is a question on the end. Yeah, I'm sorry. let's jump to next our Italian speaker, Marco Marsili. Welcome again.
Thanks, Jedrzej.
Hosted you in again on Mickiewicz University, but now in Poznań, not the Sublice like 2 weeks ago. So today your presentation is about navigating the future, human rights implication of artificial intelligence. Marco, so let's begin your presentation. Yeah, 15 minutes, okay?
Thanks, Jedrzej. I will try to contain it within 15 minutes and less. So thanks also to the IPSA Research Committee 26 on Human Rights for having organized this special panel within this conference Beyond Europe. And thanks also to the Mickiewicz University for hosting this very insightful conference. So yes, as you reminded me, this is the second time in the last 2 weeks that we gather for a conference. And that's why I've chosen another topic, because I don't want to propose the same presentation that I presented 2 weeks ago. So I have drafted a small presentation, sorry, with PowerPoint. If you are able to see it, please tell me. Can you see it?
Not yet.
Not yet. I'm sorry. Just 1 second. Share. Yeah, it's this one. Okay. Okay.
Yeah. Okay. Yeah. We've got it.
Thanks very much. So you see the curtain opening now?
Yes.
Yeah, it works. Yeah, thanks very much.
I remember your presentation are always so
yeah, right. This is the only thing that all my presentations shared. Only thing. Okay. So thanks very much. So yeah, the topic, as you reminded, is okay. The topic of the panel, what is our human rights, and also of our research committee. And the topic of the conference is artificial intelligence. So we try to put both the things together. And usually I focus my current research, just to tell you something more, focuses on cognitive manipulation in the future metaverse. That is 3D social media enabled by artificial intelligence, which will provide real life-like experiences through augmented reality, like mixed reality, augmented reality, these immersive realities. There are many realities, so using devices and so on. And with something completely different from a classic social media, because it's like classic social media is we stay in front of a screen, we are not inside. So you can figure out the impact of cognitive manipulation in the future metaverse. And another topic of my research is the compliance of laws, lethal autonomous weapon systems that are driven by artificial intelligence. So it's something that it triggers many concerns, and not only to me, but to all the international community about the compliance with international humanitarian law. But now I've chosen to present you something to talk about, to focus on international human rights law that is something different, even if it's deeply interconnected to international humanitarian law. So it's not the same thing, but they are deeply interconnected. So as artificial intelligence continues to reshape society, it presents unprecedented challenges for human rights. So in this presentation, we will explore these ethical dilemmas that artificial intelligence brings, such as privacy concerns, algorithmic biases, and its impact on individual autonomy. So we will also discuss regulatory gaps and propose strategies to ensure artificial intelligence development protects human dignity and rights. So it's on the same line of the previous presentations. So artificial intelligence is revolutionizing sectors like politics. We all know we should talk about deepfakes and healthcare and communication, and often outplacing existing legal and ethical safeguards. So this rapid transformation introduces risks such as mass surveillance, algorithmic biases, and the manipulation of human cognition. It is, as I told you before, one of the main fields, my topics of my current research. So the objectives of these presentations are to analyze the human rights implication of artificial intelligence, examine the ethical challenges and regulatory gaps, and last and third, propose strategies for a human-centric artificial intelligence future. So, as artificial intelligence grows rapidly, presents a significant risk to core human rights. So one of the main risks is privacy. Privacy is often compromised by surveillance technologies that operate without adequate oversight. And artificial intelligence can subtly manipulate individuals' mental autonomy through personalized content or algorithmic biases. Like my Italian colleague remembered us, it's about behavioral targeting, and we can see it on a daily basis when we go through the internet. We use Google. So Google proposes to us, the search engine proposes things similar to things that we have already searched for. So it follows our behavior. It makes deliver suggestions according to our preferences. So, and creating invisible but powerful controls over decision making. So there is also the danger of systemic discrimination embedded in artificial intelligence systems, which can perpetuate inequalities in areas such as hiring, recruitment, credit scoring. There was a mention in a previous presentation, and the law enforcement. So as you have stressed before, maybe it was you, Jedrzej, China or another colleague talk about the credit scoring system that is being implemented in China, and mass surveillance system, so artificial intelligence enabled facial recognition that erodes anonymity in public spaces. And cognitive manipulation, as I told you before, that is one of the major concerns. It's not only about human rights, but it's also a political and geopolitical concern, especially in the context of the current Russia-West confrontation. And another linked major concern that I have about the cognitive manipulation, and about also, if you go through and you read the Artificial Intelligence Act and the Digital Services Act, so you have to read them together, combined, to understand the framework that is now in place since last August within the European Union. And I'm worried that to safeguard to safeguard the society from manipulation and so on, we are putting in place a new kind of censorship that is conducted not by governments but by social media companies, the very large platforms, as they are defined in the European framework. So I still think that the freedom of thought, the freedom of expression should be defended, and we do not have to give up to our these are fundamental human rights that should be defended, and we should not sacrifice them in order to safeguard some other kind of principle that has not the same safeguard in the major human rights instruments. So one of the most pressing issues is the lack of effective international regulations for artificial intelligence. So while the technology itself transcends borders, because it's something that is virtual, so that this is what is different. Just to say, which is the difference between propaganda and cognitive manipulation or misinformation, disinformation. I mean, the difference is the scale, the rapidity, which with a false content is disseminated in a couple of seconds and reach you everywhere you are on your mobile device. So this regulatory vacuum allows for the exploitation of artificial intelligence in ways that undermine human rights. Just to give you an example, artificial intelligence-driven surveillance tools have been used to target political dissent, while automated decision-making systems can reinforce existing biases. So addressing these challenges requires a global coordinated approach. So we must now consider extending human rights protections into the digital and cognitive domains that are the new domains that are emerging, shaped by these new technologies. Concepts such as mental privacy and cognitive liberty are emerging as critical safeguards against the misuse of artificial intelligence. So imagine a scenario where artificial intelligence could predict your thought or influence your decision subliminally. So there is no longer science fiction, but this is a real possibility. So if you go back if you remember some science fiction books or movies, just like the Robot series by Asimov or Star Trek or whatever you want, you can see that after decades, this fiction becomes reality. So these rights are essential for preserving individual autonomy in an age of pervasive digital surveillance and manipulation. It's risky. It's dangerous. I mean, these technologies and the techniques that are based on these technologies. But what is much more important is preserve fundamental human rights for misuse of these technologies. So to mitigate this risk, it is vital to establish clear ethical and legal standards for artificial intelligence development and use. So transparency must be a priority in the sense that users need to understand how artificial intelligence systems make decisions that affect their lives. That is something that is totally unknown because you do not know how these algorithms work. I mean, it's starting from Google to ChatGPT and so on. So transparency must be a priority. And equally important are accountability mechanisms to address violations when they occur. And so this requires a collaboration among technologists, legal experts, and human rights advocates. So together, they can design frameworks that balance innovation with ethical responsibility. We can't leave only to governments and to lawmakers the possibility for designing and approving measures to mitigate these risks. Otherwise, somehow they will put at risk our fundamental human rights, because I told you before, if you go through the Artificial Intelligence Act and the Digital Services Act passed by the European Union, I mean, this legal framework triggers major concerns to me about the safeguards, especially regarding when we come to talk about the freedom of thought and the freedom of expression. So I suggest a multidisciplinary approach because addressing artificial intelligence challenges requires collaboration across different disciplines. So technologies, as I told you before, legal experts, regulations, and they must work together to design ethical artificial intelligence systems and legal frameworks. And this multidisciplinary approach ensures that solutions are both technically sound and aligned with societal values. So I'm going to close. So my recommendations focus on 3 key areas that are shown in this slide. This is the last slide. First, public education and awareness, in the sense that we must empower citizens and policymakers to understand the implications of artificial intelligence. Second, the creation of a comprehensive and globally coordinated regulatory framework to ensure responsible artificial intelligence use. Otherwise, artificial intelligence will be absolutely unregulated, or regulated only by the United States, which all these companies are based, the big so-called big techs. So, but you know that these technologies and the impact of these technologies does not respect borders. So, and third, fostering an ethical culture in artificial intelligence development. Technology should serve humanity, not the other way around. So by prioritizing these measures, we can build a future where artificial intelligence enhances rather than undermines human rights. So in conclusion, this is a call to action. In conclusion, addressing the human rights implication of artificial intelligence, it's not just a technological challenge. Yes, it is, of course. And we are inside the third industrial revolution, that is the internet revolution. But it is also a moral and political imperative. So we must act collectively to ensure that artificial intelligence is developed and deployed in ways that respect and protect human dignity. So this requires proactive engagement from governments, industry, academia, and civil society. So the choices we make today will shape the future of humanity, and we cannot afford to get them wrong. So thank you very much for your attention, and I will be happy to take your questions.
Marco, thank you very much for your
You're welcome.
Thank you.
Thank you. Yeah.
Okay. So questions will be on the end of the session.
Yeah.
And now, unfortunately, I can't see Professor Magdalena Šitek from Academy of Applied Science. So we can jump to Hungary, because I hope that there are, I can see Dorottya Biczi from Széchenyi István University. I'm sorry, once again. Dorottya, the floor is yours. Yeah.
Thank you so
15
much.
minutes, please, and
Thank
then
you.
we will have a
I
discussion.
have a presentation too in
Excellent.
PowerPoint, so I hope I can share it. Can you see it? Or?
Yeah.
Oh, okay, excellent. Okay, thank you so much. It's an honor to be here. Greetings to all. The title of my presentation is actually the potential impact of artificial intelligence on fundamental rights. In particular, the controversies surrounding the requirements of transparency and impartiality of software used in the judiciary. I would like to mention in the presentation the phenomenon on artificial intelligence, the threats to fundamental rights in the field of justice. I try to answer, can AI be expected to meet the requirements of the regulations? We see the most frequently mentioned benefits, proposals for solution to exploit the benefits and minimize the risks, and rejecting the AI altogether is not the way forward. The challenges, risks, and not least the benefits of artificial intelligence are nowadays affecting almost every field of science. My research focuses on the potential impact of new technologies on the right to a fair trial, but in today's presentation I will highlight some of the potential impact of AI in the classical justice field, with a particular focus on the transparency, efficiency, and impartiality of algorithms. The European Union has recently adopted a regulation, which is the first comprehensive draft regulation to limit the use of AI in this area to ensure responsible use. The document essentially classifies the use of AI in different sectors and a risk-based approach. From the point of view of risk categories, certain AI systems intended for the administration of justice and the democratic process are considered high risk, taking into account their significant impact on democracy, the rule of law, individual freedoms, and the right to an effective remedy and to a fair trial. I believe that is entirely justified to include AI in the risk category, since if we think mainly of decisions taken in the classical justice sphere, they bring about permanent and irreversible changes in the life of the individual. The content of the regulation has evolved along the lines of a number of soft law documents issued by the European Union institution, which have laid down the necessary requirements for the use of AI in the administration of justice. In my view, ethical guidelines are almost as important as the actual legal requirements for the definition of the regulation, since the regulation will only have a real impact if the ethical requirements behind it are also emphasized. Overall, the AI affects a number of human rights, but the right to a fair trial in the administration of justice is the most at stake. It is important to note that AI is not currently used in the administration of justice in place of concrete and definitive human decisions in Hungary and in other countries. Such use in the public sector seems to be a distant prospect. Nevertheless, it is worth paying attention to the theoretical approach now, as practical application is only possible later on based on a consideration of the risk identified at the theoretical level. But can the dilemma between the risk of technology and the preservation of fundamental rights be resolved? I would like to make clear that by highlighting the dangers of using AI as outlined in this presentation, I'm not advocating a rejection of AI, but merely presenting the indispensability of responsible use from a critical perspective. First, the European Parliament's position that the member states should only be allowed to use such technologies if there is a strong evidence that they are reliable and if meaningful in human intervention, and review is possible or systematic in cases where fundamental freedoms are at stake. But when can we say that there is a substantial evidence that the software is reliable? We are all familiar with the hacking of IT systems targeted by new technologies, even those considered to be the most reliable. So, can a system be completely reliable? In this context, the European Parliament highlights the need for rigorous fundamental right impacts assessment for AI systems. There is relatively little guidance on how to actually implement the impact assessment, but there are various good examples of fundamental rights impact assessments for other software, so there will be a selection to choose from. The other key element in the regulation is the conformity assessment, for which each member state will have to set up a notified body. The question that remains to be answered is whether this can be enough in the justice system. Of course, these are necessary, but this regulation and this regulation, they are in fact minimum general requirements at the level of actual application, which must be regulated in a specific and concrete way when applied in each sphere, and this is the real challenge. Of course, one could also say that human decisions are not infallible, and that the law enforcer as a person is influenced by many things in his or her decision, and that the violation of fundamental rights cannot be avoided completely, but can be striven for. Yet the presence of an AI in the procedure is, in my view, different and more than that. At this point, I think it necessary to point out that some people argue that the reason for imposing requirements on AI, such as transparency, predictability, accountability, fairness, respect for certain expectations and values, is a result of a complete misunderstanding of the way it works. But a system based on empirical distributions and mathematical probabilities cannot do even using sophisticated AI algorithms, as is compounded by the limitation of the insight to protect business interests. I can agree with these critiques more or less in the sense that we cannot have expectation that simply cannot be met in reality at the level that might be acceptable. Coming back to the use of AI in the field of justice, it is no coincidence that the public sector is reluctant to use AI in an area where the potential for violation of fundamental rights has serious consequences and implications, not to mention the issue of the state responsibility. Let us look at 3 specific characteristics of some of the benefits of AI in the field of justice that are generally seen as positive, as well as expectation of the software. The use of AI in the judiciary could be seen as a welcome step, first and foremost because it would allow impartiality and independence to be fully met by a software decision and would make judging more predictable. On the one hand, the creators of the algorithms are consciously or unintentionally passing their own value system when creating them. Further problem, at least from the point of view of impartiality and independence, is that the stages of building and interpreting algorithms are done by humans for humans and cannot avoid errors. Biases, values, human interests, and human concerns, however they are conceived. The European Code of Ethics, Impartiality and Fairness as fundamental principles. Again, fairness is a characteristic of the judge that has to be interpreted in a complex context. So in my view, it is not even possible to grasp what we expect from the AI by fairness, because it can only be interpreted in the case of the individual in relation to each decision. The main counter-argument to the predictability of decisions is that the risk of distorted interpretation of court decisions is extremely high based on statistical modeling alone. Going back to the previous point, the requirement of full transparency and fairness is a myth, firstly because of the problem known as the black box effect, which by which we mean, in short, that the exact specification of the software is treated as a trade secret by the developing company, so that its operation cannot be fully known to the person making the decision. Let's look at some solution to reduce the risk mentioned above. One key element is comprehensibility, which measures the extent to which an algorithm is understandable and accessible to those who do not have specific IT skills. Transparency and comprehensibility increase trust. The European Code of Ethics recommends that independent authorities of experts could be entrusted with the certification and auditing of processing methods or with prior advice. Authorities could issue certificates, and these should be regularly reviewed. The Commission of AI Feasibility Study states, which I also think is a key issue, that member states should ensure that effective remedies are available and that accessible redress mechanisms are established for individuals whose rights are violated by the development or use of AI system in terms of the rule of law. Almost all documents dealing with AI state that ultimate human control should be not absent from the procedures, and that this can be an adequate guarantee to remedy any violation that may have occurred in the use of AI. This raises further questions for me as to whether the provision of separate appeal forum would actually solve the burden reduction and faster resolution of cases that is another benefit of the AI, or whether it would just lead to a reallocation of cases between the levels of court. Last but not least, in relation to decisions that change people's legal situation, I would like to turn the role of the judge as a person, which is already partly involved, to capture the role of the judge in a way that AI will probably never be able to replace. Judges are by no means infallible, but people, at least at the moment, I think, have much more confidence in a process that is entirely in a human hands. This uncertainty can be real and can also be abusive, where in the case of a decision that is unfavorable to an individual, it is enough to claim that the AI was part of any stage of the procedure, and the case is taken to the appeal forum. This can be a limitation of effectiveness. In conclusion, the use of AI in the justice system poses significant risk to the protection of fundamental rights. The characteristics mentioned as advantages, when examined in more concrete terms, in most cases lead to insoluble dilemmas. There are proposal and regulatory experiments for responsible and ethical use of AI, which can and should be used as a starting point for a new direction as the public sector. The public sector will sooner or later have to respond to the use of AI, which is already very much present in the private sector. In outlining the dangers, I do not intend to argue for a rejection of AI, but the challenges to fundamental rights raise serious concern in the area of justice. And what we can be sure for some time to come is that the judge as a person cannot be replaced as the ultimate human control, at least. Thank you very much.
Thank you very much, Dorottya. Thank you for your presentation. So I can see still the Professor Šítek, so it's mean that we have more time for discussion. Excellent. So we have discussant Furkan Ahmed from Pakistan, but also Furkan is a secretary of RC26 board. So Furkan, if I may ask you for some your comments or questions or summary of this session, and then we will jump to the question from audience.
Yeah, thank you so much, Professor Skrzypczak. I welcome all of the distinguished speakers, presenters to this wonderful conversation or discourse or AI on human rights. I would start off with our keynote speaker's presentation, which was revolved around the use of AI on human rights and with specific focus on the vulnerable groups. So Professor Dr. Francesco Bariffi, who claimed that AI and its potential impact on rights and the classical justice. So I'm sorry. So his basically his discussion was revolved around the UN approach and AI and its framework for international relation. Let's say on the global role, it says that since 2017, the UN has recognized AI as a global mainstream issue with a focus on its potential and to shape international relations, such as with a specific focus on transformative technology, which is considered to be seen as both opportunity and as a threat, as he spoke about. The key concern for AI was, as spoke about, the legal weapons systems, which is AI used in military technologies. The other main issue that he highlighted was I'm also the biggest proponent of misinformation and disinformation and how it can be tackled specifically on the digital spaces, such as how people are using or manipulating the digital platforms, as Professor Skrzypczak considered the digital platform as a planet. So, I mean, people need to be very vigilant about debunking those disinformation and misinformation. Cybersecurity is another threat that he considered and he also talked about UN Secretary General's role in it. The impacts, like core aspects of human rights, dignity, which is again, I must agree that it's a threat to from AI technologies like neurotechnology and genetic engineering, potentially undermining personal dignity. Equality on the basis of risk always exacerbates or the divides at three levels, which he indicated, like personal, economic, and geographical, leading to a digital divide. Access to AI technology is not equally distributed, and emerging biases create new forms of discrimination. Privacy, I would say, in other words, the threats of anonymity is always, being categorized with privacy through AI, which escalates surveillance, putting personal privacy at risk, and changing how we think about data protection. Liberty of opinion is another issue that basically hinders the users on the influence of AI. The right to freedom of speech and access to information sometimes eroding anonymity, as I indicated, and the right to express oneself freely. He did talk about some of the vulnerable groups who are being affected through the means of AI, people with personal physical challenges, women specifically affected by the biases, such as I mean, the country that I represent or the region that I represent is always, very fragile against the role of women. But it also, on the other hand, we did have great examples of promoting great women leaders, but still, women are vulnerable. Children, again, these are the very easiest prey where that can manipulate minds through AI. So I also would like to ask question to our respected keynote speaker on the basis of vulnerable groups. As Professor Skrzypczak, you remember day before yesterday, I talk about how religious nationalism causing problems for people with religious minorities on digital spaces, right? I've shared some of the examples from France, Germany, and United Kingdom, India, and Pakistan with some extent. So I would request the keynote speaker to share a light on the vulnerability and its impact on, or is it also possible to add religious minorities in his dissertation? So I'm just asking question, then I'll come back to another review of the speaker.
Okay, please. Speaker is Khan.
Well, thank you for the recap of this session, which is amazing. Thank you. As regards your question, let's see if I got it right. I think your question is, what would be my approach in relation to religious minorities, right? Okay. Well, honestly, I have not addressed this group as a group in a situation of vulnerability. But my guess is that, well, I did refer a little bit about how this technology is affecting on the right to freedom of opinion and access to information. So normally in human rights, we distinguish freedom of opinion from freedom of thoughts. Consider that one is more external and the other one is more internal. So basically, what's AI is its impact now, more evidently, is this external dimension, which is not what we think, but rather what we say, what we express, what we communicate. Is not within our internal. So I'm just trying to refer here out loud, and see if if you follow me in this reasoning. So religious minorities, freedom of thoughts, freedom of religion, these kinds of freedoms are, embraced in human rights in a rather similar category. Consider that they're meant to protect human conscience from but more in an internal, as I mentioned, an internal aspect is whether and of course it has an external it does has an external dimension, because of course if you're a religious minority, you have the right to profess your cults and go to your temples and do your carry on your rituals, but I would say that these groups, we are facing a more general threat on how this technology is impacting on the individual internal dimension of this freedom of thought. And I think that that there is a great danger that this technology, the manipulative dimension of this technology, it's really a threat in the sense that I think that is an effective technology to use against religious minorities, but not by, but even by persuading, convincing, and manipulating communities to switch and into another direction. It doesn't matter which one, but I would guess that if we don't safeguard these rights, we are going to see an undermine, a diminution of the different minorities, and going into a more normal, coherent, and states will try to unify, normalize, and align everyone in the same idea, thought, or opinion. Sorry, maybe it was a bit long, my answer.
No, that's amazing. Thank you so much. It's the alignment and the same alignment is the key for this. So thank you so much, our keynote speaker. So I do have a follow-up question if Professor Skrzypczak allow me to do so, or should I move to another speaker for a review or the revision? Okay. So another question, I mean, since you talk about how it impacts and its algorithms, do you really see that human rights, let's say in a broader manner, do they undermine or prohibit a classic human definition of human rights on digital spaces?
This is question to
To
who?
the keynote speaker again.
Okay.
Me?
Yeah.
Oh, sorry.
Yeah.
I thought you were referring to Francesco. Can you?
No.
Sorry.
Yeah. I sure would do that. So on a broader level, let's skip minority rights for or religious minorities aside. Let's say on a broader picture, do you see that is digital space or social media or social networks are hindering minority rights, or is it promoting, or is it has it become a proper vessel for the protection for let's say the activism? Can we freely, yeah, do the activism role or impact
minority rights? Okay. You know that there is this feature of this technology which is called the echo chambers, and which basically it's that while we think that we are open to all the different opinions and possibilities, actually algorithms and this technology are classifying us and putting us in this sort of what we call echo chambers, in the sense that we only hear what opinions or news or feeds related to our wishes and preferences. So I think that this is creating more than. I think that the challenge is, this has been outlined in the morning, the fact that we are sort of going back to a new form of tribalism. So I think that there is a threat to minorities in the emergence of a tribalism. In fact, that we are going to start to see again, if we do not control this, if we do not tackle this from a human rights perspective, I believe that we are going to see a rise of new human groups. Maybe this category of minority will switch into a new category, which will be more global, which will be not so much related to a specific geographic or specific culture, but more a global, but still compartmentalized. I'm sorry, I can't say that word. Very in very isolated groups, but with no or very little dialogue between these different groups. So I see a rise of conflicts. I see a rise on human rights violations, and of course, this I think it goes backwards to the human rights discourse, and it's a real threat.
Thank you so much, Mr. Bariffi, for comprehensively responding to my questions, which somehow were diverted from the topic. But I mean, since we are celebrating Human Rights Day, so I thought to incorporate this question. And thank you so much for your presentation. Looking forward to your final thoughts and remarks on the paper as well. So I will quickly move to Professor Francesco Cirillo, if I'm sorry if I'm pronouncing your name right, which he talked about, I would say that he did challenge the status quo of AI itself. So this would be an interesting, discourse, but in his discourse on AI and cognitive manipulation, which talks about our European legislator chasing the shadows. Okay. So I would be somehow giving a recap on talking about the shadows or something, but for the people who are joining in person, I would request the presenter to somehow talk about the Brussels effect in his response, which again, in his presentation, he talked about the regulation balance and proportionality, that its critique centers around whether EU's AI regulation strikes the right balance and truly proportional. There are concerns that EU may be proposing a risk-based approach that is more about theoretical threats rather than immediate tangible risks. On the point of cognitive manipulation, which is again has been the center of this debate, that the EU AI Act fails to define the term cognitive manipulation. would request the speaker to sort of shed light on that as well. And precautionary approaches or the stance that has been taken by EU, which is considered restrictive and overly cautious. This approach, which classify AI as dangerous prematurely, risks such as stifling innovation and creates a deterministic libertarian view. Legal clarity also needs to be responded or tackled in the EU Act, which lacks clear and legally grounded definitions, imbalanced regulation, and political orientation. That there's a concern that AI Act might not be politically neutrally or sufficiently supportive, proportionality, and innovation. So thank you so much, Professor, for your thoughts. So can you please talk about the Brussels effect and then we can move forward.
So thank you, Professor Ahmed. And so the question regarding the Brussels effect and then some criticism regarding free will and as a legal concept, no, or cognitive manipulation. Well, while the European Union aspires to shape a global standards, I would say, particularly in fields like data protection with the GDPR, the current reality is in AI is somewhat different, and still it was different in information technology as a whole. So for now, Europe heavily relies on technologies developed outside its border, particularly from United States and China. So the effect that we see is a contrary effect. So like a extra EU effect that is influencing European Union way of life. Many of the AI system being used or maybe integrated into European markets, large language models, cloud services, and so on, originate from companies like OpenAI, Google, or Chinese firms. And sorry, I hear something. Oh, well, okay.
Yeah.
So the Brussels effect in this case might influence how these external technologies adapt to European rules, but it also underscores the critical challenge. Europe needs to invest significantly in its own AI ecosystem to truly lead and export its standards globally, not just regulating external technologies. Without this, the EU risks regulating from a position of dependence rather than strength, which could weaken the long-term impact of its regulatory framework. Free will. The ambiguity arises from whether free will should be treated as a presupposition of any fundamental right or as a substantive legal right, like an autonomous right. In some neuro rights catalogs that we see now, we have the right to free will. Well, if free will is assumed as a presupposition, it functions as the foundation upon which legal accountability, rights, obligation are built. In this view, free will cannot be itself the content of a single right because it underpins the entire structure of the legal system, even if it could be false, okay? In general, the law assumes that individuals are autonomous agents capable of making rational decisions. Without this presupposition, concepts like responsibility or liability collapse or change totally, at least, no? Consequently, regulating or protecting free will as a specific right would be conceptually incoherent. It's not a part of the right of thought. Thank you to Professor Bariffi, which has spoken of the external part, because the internal part is very problematic. So free will as substantive right, I know there are several ideas and there is the Neuro Rights Foundation and so on. But free will in our general legal theoretical framework cannot be, in my opinion, both a presupposition of the law and the content of a substantive right. If it remains a presupposition, it operates invisibly, but fundamentally within the legal system. If it becomes a right, it risks undermining the universality and conditionality of human rights. The human rights of the Declaration, for instance, that move from the human being with the free will and the dignity in this meaning. So it's like a paradox. I don't know which is the answer to the question. And the other problem is we can't speak so easily about free will in a context like the context of neurotechnology. Because neurotechnology and neuroscience, so in this field, the free will is the question. It's not an assumption. It's one of the main questions, and we don't know. Also because neurotechnology and neuroscience, if free will is a useful concept. I don't know if I answered the question, but it was very difficult to try to do it.
Yeah, yes,
Okay,
yes.
Volkan, if I may ask you about a very short question to
Sure.
China.
Next speakers, yeah, Marco and
Okay.
yeah,
Sure.
okay, because we have maybe 5 minutes.
Okay.
Yeah.
Oh, okay, sure. So thank you so much, Professor Cirillo, for your the great answers and response to this. So I will be talking about Professor Marco Marsili's research, which is navigating the future of human rights implications of artificial intelligence, which again resonates with our former colleague just spoke about that the impact of the threats of cognitive manipulation. AI's role in society continues to reshape society, presenting challenges for human rights, particularly in the areas of privacy, autonomy, and human dignity. So, can you relate that to the point that I raised, Professor, with autonomy and perhaps the anonymity, the issue of anonymity? That would be the question. And he also talked about the ethical challenge and regulatory gaps, such in the case of absence of global ethical standards. The lack of global consensus is there on ethical standards of AI that creates significant regulatory and enforcement challenges. There's an accountability issue, which is, again, needs to be addressed carefully because there's an insufficiently mechanism of AI misuse, especially in the process of hiring, recruiting, and scoring system. Just in the case of, I would say, the ATS-based technology, which just puts your CV or resume and scores some of the prominent candidate for the position of who he or she has applied. Thirdly, there is a mitigation of AI risk. He spoke about the transparency of AI system that needs to be more transparent to ensure public trust and understanding. Accountability mechanism needs to be stronger to have a check on the issues of the mishaps or the wrongdoings of that are being caused by AI itself. He talked about the collaborative part that we need to work together to design or form the user-friendly or result-oriented mechanisms for our generations to come. So thank you so much, Professor Marco Marsili, on your presentation. So I did ask you a question about the autonomy versus the anonymity in the presence of human rights.
Yeah, thanks very much for having chaired this panel and for your question. And yes, there are, I mean, it's clear that there are some concerns that have been identified by all the scholars, the plurality of scholars, even if we have different approaches from different disciplines and so on. But we all have spotted the same risks in artificial intelligence and AI enable the technologies that jeopardize our fundamental human rights. It's just we do not have. I mean, there are the so-called, we can call them secrets, but they are the algorithms that are behind all these technologies. So you don't know how it works. The algorithm that is behind Google or Bing, that are the only two very large search engines that are defined by the EU framework on the digital service and artificial intelligence. Both these acts that read together, they constitute the regulatory framework within the European Union. So only two search engines according to the European Union definitions. And the other ones are very, very large platforms that are only 17, but are all these major big techs like former Facebook, now Meta for the metaverse, and I told you before, that's something that is very interesting that we will assist in the coming years. And of course, we don't know how Facebook works. We don't know, even when you book a flight on a site like Ryanair, EasyJet, whatever you want, you don't know how it works, but there is an algorithm behind. You don't know how it works because it traces your IP and it recognizes you. So if you come back after 5 minutes, it says, okay, only 2 seats left with this price, but it's not true because it seems that it decepts you and makes you. It shapes your mind in a way that you think, okay, if I do not buy right now this seat, there will not be in 5 minutes the same seat with the same price. But it's not true. It's only because the algorithm traced your behavior or preference, and so is misleading. This is a misleading behavior, but you don't know how it works. Okay. You can check the outcome, you understand the reasoning behind, but you don't know technically how it works. So, and also our preferences, coming back to your question, and our behaviors, our choices as customers, European consumers, and so on, and as human beings, these preferences, behaviors are traced and worked in a way to take some profit, economical profit, proposing something similar to what we have searched and so on, and hiding other choices, other preferences. So we are driven, and they know who we are, but we do not know how these data are managed, because all these companies that I mentioned, just a few, but not to mention them all, but like Google, Meta, former Facebook, Twitter, now X, so X former Twitter, and Bing, that is Microsoft, and all this big tech. So WhatsApp also, that is owned by Meta. So all these very large platforms, social platforms that we use on daily basis for exchanging messages, for searching information, and so on. Somehow they use our data, so they know us, but we do not know how these data are treated, how these algorithms work, because these are covered by these are trademark and registered. I mean, this is a property of these companies. So this is one of the major challenges. And all these companies are based in the United States, as I told you before. So artificial intelligence and misinformation and data gathering and the privacy violations, they do not respect borders, unfortunately. That's why. But the problem is that Europe is very, very weak, because after a couple of years was not able to close an agreement on tariff on on the trades with the United States. So this is an old continent, but it's not leading the world. So we are slavishly following the line that is shaped by U.S. companies and governed by U.S. policymakers, and so this is a pity because I mean we have a very advanced, one of the most advanced instruments on human rights in the world, that is the European Convention on Human Rights. I mean it's a shame, a real shame that we are not able to protect in this environment, digital environment, our fundamental human rights as we have protected them since the French Revolution onwards.
So much, Professor Marsili, for your great remarks over the question. So I'll quickly.
I'm sorry, we have
sure.
only 1 minute. 1 minute,
Okay.
and fluently. Then
Sure.
we'll jump to the next session. Yeah.
Okay, sure. So, Dr. Dorottya,
We can move this discussion. Sorry, we can move this
sure,
discussion to the next session. Yeah.
Sure.
It's not a problem, of course.
Okay, problem. Okay, great. So, Dr. Biczi's presentation provided a critical examination of intersection between AI and the justice system that was emphasized with both its potential benefits and risks. As AI is increasingly integrated into justice administration, its application raises important questions about the preservation of fundamental rights. Dr. Biczi highlighted the need for specific sector-based regulations to ensure AI systems respect core values such as fairness, transparency, and impartiality. And particularly, she stressed the importance of human intervention and rigorous impact assessments to prevent bias and ensure AI compliance with ethical standards. The ongoing debate between technological advancement and the safeguarding of fundamental rights remains central, especially as AI systems continue to evolve. Dr. Biczi's call for a European Code of Ethics and regular views of AI systems underscores the importance of maintaining oversight and ensuring that AI remains a tool for justice, not a threat to it. Thank you so much, Professor Dr. Biczi, for your presentation. So, Jedrzej, I hand it over to you, and then we can carry on the discussion part.
Dorottya, if you allow me, but maybe your answer will be in next session. It is okay for you?
Well,
or maybe very shortly.
Work, actually.
Because we have only.
Can we give 1 minute to Professor Biczi for just wrap it up?
So yeah, okay.
I can
very
go
shortly.
To the next session.
Yeah.
I have to go, so I'm so sorry. But yes, I'm sorry.
So okay, now or later you will answer.
Oh, there. Sorry, I don't understand the.
No. Jedrzej, I did ask the question. I just summarized how she responded and how.
Yeah. So maybe we move this.
We change the room
and to the next session. And sorry, but next session will be on the separate link. Yeah. Okay. Please remember, yeah, you have this link in message, yeah. So please switch on the new link, yeah, and we will start at 5 p.m. It's for 2 minutes, okay. Thank you very much for all speakers for this session, because we now we entered the recording.